Good afternoon, students. I am Vaibhav, Assistant Professor Law, IIMT College of Law, and I will be talking about Section 299 of IPC and Section 300 of IPC. I will be telling you the difference between Section 299 and 300 of IPC. Firstly, let us deal with the Section 299 of IPC. Now, the Section 299, if you'll read Section 299, Section 299 says whoever causes death of a person and the act by which the death is caused is done with the intention of causing death. Now, the first point was the intention of causing death. The first thing, which is most important in the culpable homicide, is the intention of causing death. Now, the second point, the act is done with the knowledge, the act is done with the intention of causing such bodily injury which is likely to cause death. Now, the second point says the intention of causing bodily injury which is likely to cause death. Now, in first point, when we'll see there is a presence of intention of causing death, and in second point, there is a presence of intention of causing such bodily injury which is likely to cause death. Means there is a presence of some bodily injury which is likely to cause death, which may cause death. Okay, it is not sufficient to cause death, but it is likely to cause death. Okay. Now, when we'll see section 299 part 3, means subsection 3, we'll see there is a presence of knowledge, means the act is done with the knowledge that death may be caused by such an act. It means there is a presence of intention in first part, there is a presence of bodily injury which is likely to cause death in the second part, and in third part, when we'll see, there is a presence of knowledge. Now, there is a difference between intention and knowledge, and we must be very clear between when we'll see the difference between intention and knowledge. Now, intention is what? When you are doing any act, and at the time of doing that act, what is your state of mind and what are you thinking? Like, I'm about to hit anyone, so I'm thinking of what? I'm of I'm thinking of hitting that person by a stick, maybe by a rod, and at that time when I'm acting in furtherance of that intention, you know, that intention is formed at very moment when I am committing that act. And the knowledge is we'll see that knowledge is something like there is existence of such facts, existence of some facts which are present, and I'm aware of that fact. Like, if any person is standing in front of me and he is suffering from any like disease, some disease, like he has a infected spleen. Now I have a knowledge that if I'll hit on that body part, on that spleen, he may die. Then that intention, that knowledge will be considered as part 3 of section 299, and I'll be liable under section 299 clause 3 of IPC. Now, there are three things which are very important if you'll see section 299. The first thing is intention, and the second thing is some bodily injury which is likely to cause death. And if you'll see the third thing is knowledge. There is a presence of some knowledge about some existence of some facts. Okay. So this is all about section 299. And if you'll see section 300, when I'll start section 300 says, except in the cases hereinafter accepted, all culpable homicides are murder if it is done with the intention of causing death. Now, what is the difference between section 299 clause 1 and section 300 clause 1? Both clauses says the act is done with the intention of causing death. So what is the difference between them? The difference is, when we'll see section 299, it covers all the culpable homicides, but if we'll see section 300, it covers only culpable homicides which are covered under category of murder. Okay, like you all know, all culpable homicides are not murders, but all murders are culpable homicide. It means culpable culpable homicide is a genus and murder is a species. Okay, like so what it says, section 300 says, except in the cases hereinafter accepted, all the culpable homicides are murder or will be murder if it is done with the intention of causing death. Means, except in the cases hereinafter accepted. It means the exceptions which are given under section 300. There are five exceptions which are given under section 300. Those exceptions are, the first exception is grave and sudden provocation. The second exception is sudden quarrel. Third exception is right to private defense. Fourth exception is if you are a public authority or public officer and you are doing any act to prevent a bigger harm. And the fifth part is necessity. If you are doing anything which is necessary for preventing a bigger harm, then your offense of murder will be excluded. Okay. Now, if we see section 300 clause 1 says the act is done with the intention of causing death. Means all the cases which are covered under culpable homicide or the exceptions of section 300, they all will be accepted. Now, other than those exceptions and the culpable homicides, all the culpable homicides will be murder if it is done with the intention of causing death. The first part of 300 says it. Now, the second part of 300 says, if the act is done with the intention of causing such bodily injury which is likely to cause death to the person to whom the harm is caused. It means section 300 clause 2 says, it talks about some particular intention. It means if I am causing death of a person and I am not aware about the person to whom I am causing the death. It means like five persons are coming in front of me and I am shooting and I don't know whom my bullet will hit and who will die. Okay, there is some ambiguity. But if we'll read section 300 clause 2, there is a particular intention. It means the person at number 3 is my aim. Okay, I'm pointing the gun towards number 3 and and I'm shooting, and that act is of such a nature that it is likely to cause the death of the person to whom the harm is caused. Means the harm is caused to the person who is at number 3. That particular intention of that person who is at number 3 is more important. Okay, in section 300 clause 2, the particular intention is the most important thing in section 300 clause 2. First clause says about intention. The second clause talks about particular intention. The particular intention, the particular person to whom the harm is caused. Okay. Now, if we'll see section 300 clause 3, section 300 clause 3 says, if any person is causing death of a person and the death is caused by such an act which is done with the intention of causing death, and the act was sufficient in ordinary course of nature to cause death of the person. Okay, the person to whom the harm is caused and the person who is dying, the nature of the injury is of such a nature which is sufficient in ordinary course of nature to cause death. Like I'm shooting someone at point blank range, then the person is going to die because that injury is sufficient in ordinary course of nature to cause death. Okay, he will not survive if I am hitting him at point blank range. Okay, so the nature of injury is such that the it is sufficient in ordinary course of nature to cause death. Like if you'll see, most of the murders, the cases of murders are covered under section 300 clause 3. Okay, and if you'll read section 300 clause 4, we'll get to know the act by which the death is caused is so imminently dangerous that it must in all probability cause death. It means there is no possibility that the person to whom the harm is caused will survive, because the nature of injury, the nature of the act is such that it is so imminently dangerous that it must in all probability cause death. Means that person is not going to survive in any other way. The person to whom the harm is caused will die for sure, because it is written there, it must in all probability cause death of the person to whom the harm is caused. Okay, this is section 300 clause 4. Now the main points of confusions are section 299 clause 2 says the bodily injury is of such nature that it is likely to cause death, and section 300 clause 2 also says the same thing, but the difference is there is a particular intention in 300 clause 2, and in 299 clause 2 it is of general nature. There is no particular intention. It means a flock of sheep is coming and I am shooting at, and I know that any sheep may die. I'm not sure about which sheep is going to die. This is section 299 clause 2. But if we'll see section 300 clause 2, I have already explained it. A group of 4 people or 5 people are coming in front of me and I am aiming at the person who is at number 3. Then I am shooting and the death is caused of the person who was at number 3. Okay, so there is a particular intention. It is not a general intention. It is a particular intention. Means I am aiming at a particular person and that particular person is dying because of my act. Okay, then it will be covered under section 2, subsection 2 of section 300. Now, if we'll see section 299, clause 3, it says about knowledge. It says about knowledge, the knowledge of certain facts which are in existence. Okay, the person knows, the person have the knowledge that by such an act death may be caused. Okay, but if we'll see section 300 clause 3 and section 300 clause 4, section 300 clause 3 says the act by which the death is caused was sufficient in ordinary course of nature to cause death of any person. Now, the act was sufficient in ordinary course of nature to cause death of any person. It was sufficient in ordinary course of nature to cause death. Means there is no likelihood. There is no likelihood. But in section 299, there is a likelihood. It means there is a chance of that person may survive. The nature of injury is not so imminently dangerous that it must cause death in all probability. Okay. As in section 300 clause 4, it is given that the nature of injury is so imminently dangerous that it must in all probability cause death of the person. Okay. So section 299, in section 299 there are 3 things. Those things are, the first is intention, the second is bodily injury which is likely to cause death, and the third thing is the knowledge. Okay, but if we'll see section 300, the section 300 clause 1 says about the intention, section 2 subsection 2 of section 300 says about the particular intention and knowledge, and section 300 clause 3 says the nature of injury was sufficient in ordinary course of nature to cause death, and subsection 4 of section 300 says the act was so eminently dangerous that it must in all probability cause death of the person to whom the harm is caused. Okay, so this was all about section 299 and section 300. Now let's talk about some cases. There was a famous case about of culpable homicide and murder It was Palani Gundam versus Emperor. In this case, there was a quarrel between husband and wife. The husband hit the wife. The head of the wife was hit by a plowshare, and the wife became unconscious and fell on the floor. After that, the husband of the wife, believing the wife to be dead, he created some false evidence, and in order to create false evidence, he pulled his wife and he just hanged her on a fan and created false evidence. He reported to the police officer that my wife has committed suicide. Now, after the postmortem, it was clear that the death was caused due to strangulation and not by the injury which was done by the plowshare by the husband. Now there was a complaint and the FIR was registered and the case came up in the court. Now what happened in the court was the judges were in the confused state of mind because the death was caused due to strangulation, and the strangulation happened when the person was creating false evidence. But the person who believed her to be dead at the time when she was unconscious was not held liable for either murder or culpable homicide, because you can't kill a person who you believe is already dead. Now, the intention to uh, cause death was not there. The husband who hit her wife, he did not intend that his wife will die out of that injury. His intention was just to hit her because of the anger. His intention was not to kill her. Okay, so there the first clause was unsatisfied in this section. The second clause of 299 says the bodily injury which is likely to cause death. No, the bodily injury was of such a nature that it was not likely to cause death. Okay, the section 299 ka third part says the knowledge that death may be caused. There was no knowledge that death may be caused by such an act. So section 299 was not applied in this case of Palani Gundan versus Emperor, and section 300 also was not applied. And the person was held liable for grievous hurt, which is covered under section 320 of IPC, and he was booked under section 192 of creating false evidence of IPC, and he was not liable either under section 299 either under section 300. Okay, this was all about section 300 and section 299.